Thank you, Mr. Speaker. I join with the Chair in support of all of the changes that were added in the Senate. They were thoughtful and, I believe, not just appropriate but necessary. I don't want to pile on the same statements made already because they were accurate and I agree with them. Rather, because there has been fairly public pushback from some members of the Article III court that we are meddling in their business, I've given it a lot of thought and discussed it with a number of scholars, and I think the American people need to understand that the executive branch does not have the authority to pass laws, and the judicial branch does not have the ability to pass laws. So when it comes to establishing laws for transparency, reporting, and the American people's right to know, there is, in fact, only one body that can initiate and send, for the President's signature, statutes of transparency and accountability. So even though this is a 1978 law being modified, the fact that there is pushback from a branch saying that under separation of powers we're somehow meddling by substantially harmonizing what the executive branch and this branch do to make sure the American people have confidence in what we own that might in fact be influencing what we do, seems to be one of those areas in which I believe the American people, properly explained, would fully support. And so for that reason, I would hope that as this bill becomes law, that the members of the court would recognize we had no choice. Faced with clear examples, even one being too much, of a judge who had holdings and simultaneously affected the value of those holdings while either owning them or trading them or both, that we had no choice but to recognize that that absence of transparency was critical. I want to simply close off by saying this is likely not to lead to a lot more recusals, but this is certainly going to lead to the kind of information that attorneys need to have on behalf of their clients when they're working through a case. If you know that a judge or his spouse or her spouse owns something, why wouldn't you be aware of that when you have a case involving that company? If you know that they own a substantial amount of a sister company, one that is not involved in the litigant, but in fact could benefit by an adverse decision, the attorneys for both sides should know that. So we're not just dealing in the failure to recuse here. Reporting transparency, in fact, empowers both sides to know the lay of the land that might be very meaningful in a case. Yes, there will be some who see that and ask for recusals. And I trust that judges who, after the fact, when these 130 cases were reported, some of the judges said they didn't even know about it. They didn't know they had it, or they didn't know their spouse had these holdings. That may very well be true. Some of them said they didn't know they were supposed to report. That may be true. But if, in fact, when this is implemented, we will be in a position to say, of course, the public knew, and empowering the public on this not private information, because ultimately we are public officials. I am a public official, the chairman is a public official, the speaker is a public official, and so are those honored to serve as magistrates, bankruptcy judges, and Article III judges. So I hope that this minor change will represent a major step for us in bringing back the confidence of the American people that they do not have to blindly go into a case not knowing whether the heavy hand of law might be weighing against them without their knowledge. With that, I reserve the balance of my time.
The gentleman from California reserves. The gentleman from New York is recognized.
Mr. Speaker, I have no further speakers, and I am prepared to close.
The gentleman reserves. The gentleman from California.
Mr. Speaker, it seems only like yesterday I was speaking on this subject. This is an important step. I know that we will have broad bipartisan support on it. I hope that we will have not just acceptance, but an embracement by the judges who now will be reporting and providing more information to the public that the public has, and particularly litigants, have every right to know before they go before that judge. And with that, I thank the chair for his help in shepherding this bill, and I yield back.
The gentleman from California yields back.